The installation change was not documented in the initial contract and was not put into a change order. Since none of this was in written documentation, if Ray decides to sue, then Jeff could use this as a defense. However, on the other hand, it could be argued that this was an implied contract between them as they spoke to an employee of Quality Construction Incorporation, who had assured them it was a doable adjustment. An implied contract is enacted by the actions of the parties involved, which doesn't require the contract to be stated verbally or written. The requirements that are needed for it to be considered an implied contract are: Jeff provided some service or property, Jeff expected to be paid for that service or property, Ray and Nancy knew or should have known that payment was expected, and Ray and Nancy had a chance to reject the services or property and did not. In doing so, this instance fits as an implied contract because Jeff Cutler provided a service with the intention of being paid. Then Nancy and Ray knew they would be required to provide payment for these services shown by signing the contract, and they had a chance to reject the service at the time of signing the initial contract. It cannot be an express contract because this is when the terms of the agreement, oral or written, are explicitly stated. For it to be considered an express contract through offer, acceptance, consideration, and capacity. An offer consists of one party making an offer to the other party. Acceptance is when the counterparty has clearly accepted the offer. Then consideration is when both parties must receive some value from the contract. And for the capacity, both parties must have the ability and understanding to enter into a contract. This does not fall under an express contract because when they have the offer and acceptance, they do not have the consideration of new compensation for the work. If they were to go to court, Ray and Nancy would sue Quality Construction Incorporation, Jeff and Dawn, who had agreed to the new terms on the phone, making Ray and Nancy the plaintiffs and those who were being sued the defendants. The jurisdiction would be in upstate New York in the civil court because that is where the business is located and where Ray and Nancy reside. In this instance, they would go to civil court rather than criminal court because in civil court it is a person of society against another person of society. It cannot be a criminal court case because it is not a violation of a criminal law. If Jeff, Quality Construction Incorporation, and Dawn were to win this case, the court would force Ray and Nancy to pay him for the work he had done. Jeff would also be required to reinstall a new installation or pay for another company to do so if Ray and Nancy were to win their case. Due to Quality Construction being an Inc. or incorporation, only the corporation itself would be liable. Jeff wouldn't be personally liable if sued. If Ray and Nancy were to win this case, then they would be awarded nominal damages. Nominal damages are awarded in cases where there are no other available damages as the party suffered no financial loss. Due to the fact Ray and Nancy had not paid for the upgraded installation, they didn't endure any financial loss. Ladies and gentlemen, the jury has made its final decision. The jury will be awarding Ray and Nancy nominal damages and forcing Jeff to redo the installation in their house.
Booyah!